So there's actually very little margin for error on us to get everything correct because the court assumes like, well, if you do it wrong, go back and redo it. Except that's not how it plays out in reality.
The Weekly Friedman, your source for the most essential information in the default industry, with your host, Adam Friedman.
Today we'll be focused on New York evictions, more specifically RPAPL 713 and New York's Good Cause Eviction Law. Joining me is Friedman Vartolo associate Rick Tracy. Rick, thanks for joining me again.
No problem. Happy to be here.
So let's jump right in. What is RPAPL 713? When does it apply? What is it?
So RPPL 713 is the provision that we use when we bring our post-foreclosure eviction actions, because that is meant for when there's an eviction where there is no landlord-tenant relationship. And we specifically use provision 5, which is about post-foreclosure. So when purchases of property after foreclosure, you are allowed to commence an eviction after that.
To be clear though, post-foreclosure, we're thinking about it simply. There's kind of two different types of parties you could be evicting. You could be evicting the old owner, but you could be evicting a tenant of the old owner. Would we be using this to evict that type of an individual as well? Or is it just when we're evicting the property owner who was foreclosed out?
So specifically, we've come across it in people who are previous owners, although you can still use 713 if there is someone who is a bona fide tenant. You just have to abide by certain noticing rules. In short, you have to give them 90 days instead of the 10 days that you would give to a former owner in your notice to quit.
Let's focus on the evictions of the old owner. The standards imposed by 713, do those differ widely from a scenario where there was a real landlord-tenant relationship?
In a sense, yes, because our case is a lot simpler. All we have to do is show that we have the referee's deed post-foreclosure and that we properly serve the notice to quit and properly serve the petition. It's an extremely simple fact pattern that we have to prove.
It makes sense, right? Because foreclosures in New York, especially in New York, can take a long period of time. So if you've lost your ownership right, your occupancy, I guess you could refer to them as your occupancy rights, really do flow from that ownership. And once you've lost ownership, it makes sense to have a quicker eviction. Is it quicker?
Well, it's supposed to be. So the whole statutory scheme of the housing courts was built to be the very quick way that someone who is an owner that has the right to take possession, it was built to be this quick summary proceeding to get you to eviction very quickly. In other words, a summary proceeding means that everything, like you think of a trial, is all summarized into a very quick process. In New Jersey, it's literally one appearance. And in New York, we actually are held to a high standard because technically it is supposed to be this very quick proceeding. So there's actually very little margin for error on us to get everything correct because the court assumes like, well, if you do it wrong, go back and redo it. Except that's not how it plays out in reality. We are facing many, many months delays procedurally. You can even attribute over a year plus in some cases. That is just purely court delay in processing our cases. So it's not really summary so much. It's not really that quick of a process in actuality.
So in essence, we could have a higher standard placed upon us, but it could still take a really long period of time.
Yeah, the stakes are very high for us, which is why we're seeing a pattern of opposing counsel raising these arguments. They have to get creative because, like I said, our fact pattern is very simple. But if somehow opposing counsel can create a clever argument to somehow derail us, that can get them an extra 2 years for their clients, 1 to 2 years in the property, if they can derail our case. So we are seeing actually in the past year or so, a lot of these arguments that, well, there's this new law called the Good Cause Eviction Law, and I think it applies, and you guys didn't follow through on its requirements, so therefore this case should be dismissed.
Let's slow down there for a second. I hear about the Good Cause Eviction Law all the time. It comes up in many conversations. For our viewers, can you break down what that means?
So the legislature created this new scheme called the Good Cause Eviction Law, where it applies a lot of the protections that used to only apply to stabilized apartments to everyone. And this protection is your landlord can only evict you for good cause. And the legislature created a list of specific reasons that a landlord would have to have, and only those reasons. It could be non-payment, it could be damage, etc. But a landlord can no longer say, I'm done renting, please get out at the end of the lease. They have to actually have good cause. And they also added certain requirements to when you bring an eviction. You have to say certain words in your petition. You have to attach this worksheet to it where you literally check off, I'm evicting you for this specific reason that the legislature has provided. In our arguments, this categorically does not apply to us because very often we're not dealing with tenants whatsoever, except a lot of opposing counsel is saying, well, I think the law applies to everyone, to every eviction, and so you need to abide by it. In our opinion, that's wrong, and we've actually won a case now on that.
So do you think there's any hopes that there'll be clarification maybe from the legislature or from a huge decision that would clearly state that the good cause eviction law does not apply post-foreclosure to owners?
Yeah, so we're hoping for that. One of the challenges that we face in our industry and on behalf of our clients is that we have to think on a case-by-case basis. Our clients, they win or lose money depending on how fast the timeline is. And they don't want to necessarily fight something to the death by appealing a bad decision. Sometimes they just want to settle because that's just how the math works out, or they want to take a quick win. So opposing counsel and legal aid, they have the opportunities to fight this. So what we want to do is to make good arguments, win in the trial court, so that there's a lot of precedent for our interpretation of the good cause eviction law, that it does not apply to our clients, which it does not, and set a lot of persuasive law. We've already won one specific case on it, and we're hoping that if it comes up again, we'll continue to win, so that if there is an appeal, whether it's one that we handle or someone else, that there's a lot of persuasive case law saying that, hey, this clearly does not apply. And a lot of these trial court judges also agree it does not apply to our post-foreclosure situation.
It's good insight, Rick. I think this is another scenario where we're digging in on a topic that on its face seems pretty simple. You're saying under 713, we're able to do a summary eviction process that'll move very quickly. But it doesn't. We're also saying that the good cause eviction law does not apply to foreclosed out old owners. But then you're saying defense counsel raises an argument. And both these things can really slow down our process and make things complicated. So I appreciate you shedding some light on both those topics. Thanks for joining Rick Tracy and I on the Weekly Friedman, your source for the most essential information in the default industry. Thanks for tuning in and looking forward to seeing you next time.